I haven't felt this paranoid about people behind me since I worked at NSA. It's a little bit unnerving, but we'll make this work. And these are a couple of amazing human beings that I'm really honored to be on this panel with. As I said this morning, I've spent a lifetime in this business thinking about the issues of not only finding flaws, but what is it we systemically need to do to fix them. And I mentioned to you kind of my change in thinking about this. So I'm going to share with you, with our panel here, these are two members of the team that wrote a paper around reasonable security that we released about a year ago at the RSA conference, the biggest trade show in the industry. So I think Julie's going to provide you a link if you're interested. The paper there's lots of stuff in it. The real meat of the paper is 15, 20 pages or so. And it's also, if you're interested in the topic of cyber law, cyber regulation, what's happening in the States, the appendices are full of that stuff. We compiled a lot of information as we tried to understand the entire landscape of these sort of problems. So I always have to start with a story, so forgive me a story. So I mentioned starting at the National Security Agency. Well, I was a 3-year intern program. Like, who gets to do that anymore? Started in '77, but my first real assignment was in the Computer Security Design Guidance Division at the National Security Agency. Now, I didn't even know what computer security was. I could barely use a computer because they were so uncommon at that time. I found myself in a office with some of the real wizards of computer security, folks that went on to distinguished careers in the National Computer Security Center and laid the theoretical mathematical foundations of what we think of as computer security today. And so I remember as the green as grass, brand new intern. And back in those days, frankly, people drank coffee all day and half of them smoked all day. But they would stand around the coffee pot. Anyone remember this? They're all around the coffee pot, and we called them gray beards because mostly they were older and had gray beards, and I somehow became one after a few decades. And they were pontificating about the future of the business and what's going on, and I'm just on the sideline. I want to learn the wisdom of the ages from these amazing people. And one of the wizards turns to the crowd and says, well, any day now, first big court case is going to prove vendors can't sell buggy software to us anymore. Huh. And I'm listening going, that sounds right. That makes sense. How can you sell known flawed products to the public? Well, here we are 50 years later. And this is the world that we live in, this complexity of what is the basic responsibility that vendors have, individuals have, companies have, users have, to deal with this cybersecurity problem. We are literally debating this every day, and including in forums like this. So let me give you a little bit of context. So for the Center for Net Security, in addition to being one of the world's largest providers of security best practices, our model is volunteerism, we give the content away. We also, our goal is not to produce the best prose, the best text. Here's the recommendations. Our goal is to provide you with an ecosystem of things that allows you to achieve the good intentions of those recommendations. And that is a big deal, believe it or not. You can find great lists of things to do and catalogs of controls on every street corner in this industry. But at the end of the day, why do you read that stuff? Because you want to figure out what to do. How do I turn it into action? One of the topics that I mentioned in my opening was about how do we look at the business of incentivizing people? This is a really interesting social problem, right? People know they should do better. They can see the headlines. They know what's happening out there. Almost everyone I know has been affected in some way by identity theft, phishing, some sort of, known of someone who's been the victim of fraud, et cetera, and yet we don't. But on the other hand, we all know we should eat better, exercise more, sleep better, and take better care of ourselves. And it's not clear that we're all really very good at that either. But something has been missing in cybersecurity around incentives, and how do we make sense of what the real risk is? How do we personalize it in an emotional way, the way Bill talked about it this morning? Enough to cause us to take action, right? There's a lot of, in this business, we call it admiring the problem. Wow, isn't that a shame? They got hacked. Wow, millions of dollars lost. So that's admiring the problem. That's not solving the problem or making progress on it. So we decided to look at this whole area of reasonableness. Kirk, in a minute, will give you a little background on the Ohio Data Protection Act, which for us was really a triggering event. I also mentioned that we interact with state and local governments every day. So about a third of our company is the Multi-State Information Sharing and Analysis Center. The acronym is ISAC. And we have about 20,000 members of governments of every size. So every day, 24/7, we're tracking incidents, sending out advice and bulletins and advisories, and that is our world. But that also gives us insight into how governments at every level are struggling to deal with this problem. So Ohio's kind of set the pace for us, and it became a partnership that allowed us to think about this whole area of reasonable cybersecurity. And as I mentioned, once I started to think about it, hunt around, I found that my old friend Stan is already on top of this thing. So I wish you'd have solved it, Stan, but instead we're going to have to keep working together until we make progress on it. So what we did was gather a working group of folks, two of them here are joining us remotely, to try to put together the context of reasonable security, right? As said, it's undefined, but really critically important. And we don't get to define it either, but we pull together the diversity of players in this space, judge, lawyers who've worked both prosecution and defense, consultants who deal with this kind of stuff every day, technologists, security people, to get a sense for what are the important properties if we were going to define reasonable, and it's going to be based on commercial standards, which was the approach that Ohio took. How do I interpret that? How can I turn that into real action when, to go from a word or a line in a piece of language to real specific action that we can look at and make sense of? So that was the backdrop of what we were trying to do. As mentioned, it was almost not quite a year ago at the RSA conference, I hosted a panel. Sam was on our panel then, and Brian Ray from a law professor from Ohio. So this is part of our ongoing discussion. That paper's been out, and then for the last year, I'd say this has been, for the Center for Net Security, our major, what we call thought leadership campaign. So I run a program of thought leadership for the company. And the idea was to use this as a trigger to engage in these kinds of conversations. We reached out to Stan about doing something together, and this is the result of that. So with that, I'm going to turn it over to our panelists. I give them 5 minutes or so for an opening statement, guys, if that would work, and that'll let them bring their context to this, and allow us to get started. We'll go into a discussion. If you have questions, jump up, grab the mic, do whatever to get my attention. We're happy to address them, but otherwise you'll hear our conversation, and I'll in effect moderate our panelists here to figure this out. So if you don't mind, Kirk, if you could join us first. Kirk is the director of Cyber Ohio. If you could give us a little bit of background on that and sort of the context of what you guys were thinking.
Certainly. Thank you, Tony. I am Kirk Herath. I am the director of Cyber Ohio, which is the state of Ohio's cyber coordination division. I work directly for the governor, Mike DeWine, and it's an executive order position, but my interaction with this issue goes back to I spent 32 years in a Fortune 100 financial services company here in Columbus, Ohio, and the last 25 years or so I was the technology group legal leader, and my clients were all of the technology folks, the CIOs of the businesses. I was worked very closely with our information security areas as well. In fact, even helped get them off the ground in a formal sense in the late 90s. And as part of that, I had interactions with any number of three-letter federal financial services agencies and state insurance departments who were sort of omnipresent in our buildings. And, we had at any one time a technology audit going on. Every quarter we had one federal agency or another in there. And, the largest part of financial controls are the technology controls that assure the integrity of the financial controls. So they really are yins and yangs. And I would say that the financial exams really were more or less technology exams. So over years, it got to be very clear that that security was important and that there were indicia that you needed to do to pass muster with the federal and state regulators. So fast forward to 2012, we thought we were doing pretty well, but we had a fairly large incident that resulted in a breach of about 1 million records ish, something like that. And it was because we missed a patch on one application on 4 servers out of the tens of thousands of servers we had.
Wow.
That netted us a 38 or 39 state AG multi-state investigation that carried on for 5 years. And as Tony said, right, I went from like a brown beard to a gray beard during that period.
Sure.
Yeah. In fact, I was looking at my Zoom picture before my Zoom picture must be 15 years old. I need a new Zoom picture. I look like a young man in that picture. In any event, as part of that, right, they alleged that we were negligent, right, that we were not reasonable in our behavior because we had accidentally missed one patch on 4 servers that had this application. And it had been human error as a result of a transition from administrative teams. It was a pull patch versus a push patch, and they didn't know that they were supposed to go out and get it from the vendor. So we were willing to sort of apologize, and we obviously we did our breach notifications according to law, and we gave everybody credit monitoring. We were one of the first companies that ever do that of our own free will. But they wouldn't go away. So we spent 5 years in major legal conflict with these folks. And over that time, right, I began to hone my understanding, at least from a defense perspective, of what legal reasonable security was, right? And it's basically a standard of care. And I kept arguing as the chief lawyer that we had met that standard of care, and we had all of these regulatory audits that showed that we had for a long time. And we also complied with, or we tried to. We followed CIS, we followed NIST, and we did our. We spent probably all in $100 million on security, if you depending on how you counted it, we network and everything else. And concurrent with that investigation, then Attorney General Mike DeWine created Cyber Ohio, which was a private sector advisory board. He wanted to come in, and he was tired of basically, he said, small businesses, medium businesses, they don't know, they're having breaches. It's not fair. There needs to be some standard by which they can judge their behavior and determine whether or not what they've done is enough, too much, or not enough. And so that was sort of, for me, a perfect vehicle to do what I wanted to do, which is to, again, sort of create a framework, or create a legal framework, a formal legal framework that actually said this is what legal reasonableness is for data security. For whatever reason, the then Attorney General made me chairman, so I got to do what I wanted to do with the vehicle that I had. And Brian Ray, who Tony referred to at the RSA, where Brian was part of my advisory board. He still is. He's still a big contributor. I still have the board. And we had 10, 15 of us that got together and put together what we thought was reasonable. Now, we had federal law telling us what was sort of reasonable. All of these audit exam guides, some of which were this thick. We had state technology exam guides that were about this thick. And then in 2016, we had then Attorney General Kamala Harris issue a report in California as the AG, who cited to CIS as reasonable security.
Yep.
So that was about the time that we were doing our bit, and we took that and we made a fairly simple law. We just said, like, you have to have a program, so you have to have some indicia that you have a program. You have to have somebody in charge of it. You've got to have, training. You've got to have, you've got to have controls. You've got to have technology. But then you have to sort of be guided by something. And so we cited to, among other things, the initial things that we cited to were CIS and NIST Cybersecurity Framework and NIST 853. And then it became a little bit of a Christmas tree with the legislative process. But that was where directionally we were hunting in order to try to define what this thing was, that it not only vexed me. I mean, I had a lot of peers in other companies who had gone through the same thing with regulators of one type or another. And so, so we were able to then come together. The business community came together, and we passed this. They passed this law. The legislature did. Then Governor Kasich signed it right as he was leaving office, frankly, at the end of 2018. And we've had this law in the books for about 7 years. So I think it's been successful. No one has ever sued under it, which tells me nobody's ever gotten sued for a data breach in Ohio since then. So it tells me that the system must be working pretty well. People would say, well, maybe because nobody got sued, it's worthless. But I think the fact that it's there, and there've been no lawsuits of any type really in that period, tells me that at least at a working level, people understand what they need to do.
Mm-hmm. Well, and we'll explore that, Kirk, I think in a little bit here.
Yeah.
Because there's again, when I was a little more naive than I am today about such things, it was like, well, like the anecdote I told, right? The court will sort this out. Well, maybe maybe that's not the best answer. So thanks for sharing, by the way. There's nothing like battle scars to spur you to action. And, congratulations to all the great work you guys have done there. So on to Judge Thumma, but if I don't call him Sam, he won't speak to me anymore because he insists. So from Arizona, Sam Thumma, who was a member of our working group and brought, I'll say, a hefty dose of common sense and plain speaking to the team. So Sam?
Tony, thank you, and thank you, Kirk. It's an honor to be a part of this panel. We have done presentations, sometimes varying who's on the panel in the past, and I learned so much from them. A quick disclaimer: I am a judge in my day job. I'm on the Arizona Court of Appeals, Division I, but I'm here as a volunteer, and I was part of the white paper drafting undertaking, which was fabulous and revelatory and delightful as a volunteer as well, a guide to defining reasonable cybersecurity. Second sort of disclaimer quickly, because it's always, I am the least tech savvy person in this virtual room, in the actual room, Tony, where you are. And I say that not out of false modesty, but because I'm the least technically savvy person in any room that I'm in, honestly. And I'm okay with that. Our daughter is an MIT, computer science grad, master's grad. So there, in the family, there's some genes like that, but they hopped right over me. But I think to the extent I added value in this white paper, it was because I didn't know anything. And that's particularly true for technology. Technology sort of baffles me, but on occasion, courts are asked to apply and determine how technology should work, shouldn't work, things like that. Kirk's described a pretty memorable experience. How about that, Kirk? with regulatory folks, and that's true, and that's where a lot of the work that can get resolved or can happen here. But the hope with this white paper was to provide some guidance so that folks never see the courts, right? I love being a judge, but we're almost by definition are generalists, and I've been a judge for almost 18 years now. And the cases I hear are civil, criminal, family, state and local tax, juvenile, administrative law, workers' comp, unemployment benefits. That's great, but the thought that I would have a a roundable subpart percentage of the knowledge that any of you in the room, or you and Kirk, Tony, certainly have is laughable. I'm asked to look at a lot. I'm either a specialized generalist or generalized specialist, right? And that comes with a cost. If you're talking about 50 years, Tony, of sort of working through things to refine and perfect knowledge, and with your own set of acronyms. We certainly in the law have our set. That's one of the things I push back on the white paper is I don't know these acronyms, so let's spell them out and see what we can do. The other thing too that I'm particularly interested in this topic and this approach in the white paper, what really caught my attention is it's designed to keep people out of trouble, and to figure out what measures do we really need to take in a concrete way to avoid problems. I am really happy when people take action so that they are never in a court. I will have plenty to do. I will have rich and rewarding days without any mondo dispute on a cyber breach. And Kirk, I think one final thing just in the introductory comments, your reference to the Ohio statute, and Ohio has been really a thought leader given Kirk's and others work on this front. The fact that it hasn't been invoked, some people might say, oh, that means it hasn't been successful. I think it's probably exactly the opposite, that it has provided guidance and has given folks a North Star, a direction to shoot at, to take actions to avoid the mischief that sometimes litigators, and I'm a former litigator, you had to put Humpty Dumpty back together after he fell down. Well, if he never fell, that's a better day. But so a long and rambling introduction for a volunteer generalist who doesn't know anything about technology, but I'm happy to be here. Happy to be here.
No, we appreciate it, Sam. And it's sometimes we forget in this industry how uncommon common sense really is. So we appreciate all you brought to that. Speaking of common sense, so Kirk, one of the things you really appreciated about what you did with the Ohio Data Protection Act was the clear pointing to existing standards, as opposed to the typical government temptation to create different ones. So what was that the debate, or what? How did that come about?
So yeah, a little bit early on there, CIS, neither C nor CIS or any of the NIST standards or ISO or any of those things are law, right? And so sometimes lawyers they kind of get dug in on, there's not a statute or a regulation, right? It's not really the law. And so what we need is a regulation. We need to write a law that says somebody needs to do a regulation. Well, again, I'm a control freak, and part of that is I didn't want to punt this to somebody that I had a sense wouldn't understand what we're trying to get at, and would come up with probably effectively what the standards do anyway, right? Because they'd have looked at the standards, and but it wouldn't have been as effective, because once it's ensconced in law, as Sam knows, right? It's darn hard to change. I mean, courts can reinterpret it, they can interpret it, but basically, if you've got a regulation, you have to go back and you have to amend the regulation. Or if you've got a law that is problematic because technology has evolved, time flows forward, and you're stuck back here with some standard that is ancient, right? You have to go back and you have to amend the law. Well, it's darn hard to amend laws. I mean, the legislatures have a million things going on at any one time. And most of the time, it's in a forward progression, forward march. They want to do new stuff, and they want to solve new problems, and they don't want to go back and deal with older ones. So you had in my regulatory practice, we sat around conference rooms, for the 15 years before we passed that thing. And we would talk about what tools we had, what processes we had, what policies we had, and then we would we'd bounce them up against first the NIST cybersecurity framework, or the NIST 853, and then we prioritized using CIS. So, I mean, this was the framework that I was comfortable using for 15 years in my practice with my clients, all of whom were highly trained, very expert. And so it seemed just obvious to me that we would hunt back to what we had been doing, and then when I would talk to peers and other companies, they did the same thing. So it was, you had the standard of care that was laying right out in front of you. And I know that in last summer, I mean, Sam did a good job of explaining what the standard of care basically just, if you meet it, you're not negligent. And so the allegations against my company was that we were negligent, and maybe even recklessly so, right? Almost intentional, right? Because we literally missed, one patch out of the tens of thousands or the hundreds of thousands that we applied that year. And so, I mean, maybe Sam, you can talk a little bit about how negligence, the elements of negligence, and then maybe I could talk a little bit about, like, the standard of care and duty and stuff like that.
I'm happy to take a run on that because it involves my hand. And the way I learned, and it's called a tort, negligence, common law tort. Old as the legal system almost. And I learned tort law from Martha Shamalis, who's now at Ohio State University, I believe, teaching law there. And she said, hey, it has 5 elements: duty, breach, and I'll come back to these, cause in fact, proximate or legal cause, and then damages, right? So all 5. And she'd write them up on the board because they're hard and they're smushy and they don't quite break that cleanly. But every day at torts class, she'd write them down and said, we're right here. So if we're talking about breach, she'd point to number 2. But duty is, what obligation do I owe to either you or the world, right? And generically, that's a duty of reasonableness. Well, what's reasonableness? Law students have wrestled with that in the abstract for years and years and years. Sometimes people get cute, and of course, an acronym, the average reasonable person, TARP, is sort of that. But then, so duty, and then the question, though, within duty is duty to do what in the specific instance? And that's where the white paper really helps refine. If you're a surgeon, you owe a different duty than if you're a driver, than if you're a pedestrian, than if you're a food provider, than if you provide drams to someone. So duty and the scope of that duty is really significant. And then whether you breach that duty, and that, as Kirk said, if you have the thumb and the finger, other things sort of start getting moving forward. So if you have a duty that you've breached, then you're looking at, well, what are the consequences of that? What are the legal consequences of that? And what kind of harm did it create? But our focus is early on that, both the duty, the scope of that duty, and that helps define whether there's a breach, and what then the consequences are. So that's the Sam 5-finger sort of description of the common law tort of negligence.
And then let me just to put an end on that. Then the standard of care, right? It evolves over time. Like and Sam, appropriately talked about medicine is all about standard of care, right? And it still is regional to some degree, but it's more national now with boards and of different types of medicine. But it evolves over time. What was reasonable in 1952 is not reasonable today, right? And you have the same problem or issue with cybersecurity, right? What was reasonable in 2005 is not reasonable necessarily in 2025. And so you have to sort of follow the technology, and the standard of care effectively changes. And that Tony, is another reason why we went back to the standards, because both CIS and NIST are effectively open source, right? And they evolve naturally over time. You get every once in a while somebody says, I think we should go from NIST, 1.0 to 1.1 to 1.2 to 2.0. And and then you bring people into a room. That's literally how they do it. Everybody, I don't know about CIS, but NIST is, they have regional forums, and everybody sort of, says, I think it should be this, I think it should be that. And they sort of find the balance in the middle, and it sort of self-corrects, and you end up with a reasonable approach for a certain type of control, based upon kind of national consensus that's been kind of, taken to its mean, so to speak.
This idea,
And whereas like a regulation, back to what I said, a regulation it's ossified. It just sits there. It sits there, it doesn't change, nothing changes. And so it's not good. It's not good public policy, frankly, to keep, particularly in this space where the technology evolves so quickly. So.
that's really a compelling argument, because one of the things we talk about at CIS is a sustainment, over time, right? These are evolving problems. Bad guys change, technology, business use of technology, all change. And if you also have to look for, so you based it on things that were either self-sustaining or had a sustainment mechanism behind them, as opposed to another top 10 list or, and with all respect to my friends in the federal government, I spent most of my life there, the political process means sometimes the federal system will get excited about a problem, throw a lot of money at it, and then move on. So it isn't necessarily sustainable over time. And just a shameless plug, this is the 25th birthday of the Center for Internet Security. So we've been doing this a long time, 25 years, continuously producing these security benchmarks. And so, it is in our business model to keep things current. And I think, you really pointed out how important that is. Sam, back to the paper, there were a bunch of other things beside the paper. I've heard you say before, right? There's probably 15, 20 pages of text, but all the other stuff that's in there and how that was valuable. Oh, and I think the audience has already gotten a glimpse of your common sense, five-finger approach to help keep us on track. So appreciate it.
It's all I got. That's honest, honest. But what we ended up doing, and some of this was, it was a team effort for sure, but some of this really was, I did have a hand in, it's a hub and spoke, right? I mean, the paper itself, it runs 76 pages, but the guts of it are about a dozen pages. And the thought being, hey, we can give you detail and depth in glossaries and appendices, and the paper does. But this is written for folks to both who are at a pretty high level of sophistication, and then people like me who are strangers to all this and are just trying to struggle to understand what terms mean, where we go. The thing that I was so impressed with, because the law almost always, maybe always, lags innovation, right? Innovation, especially in technology, will outstrip the law. And so to write, like Kirk has had a significant hand in, statutory provisions that provide guidance, provide that North Star with some granularity, but also with enough breadth that, changing from the Betamax, sort of tape to what we have now, it can still account for that. And that's the brilliance of it. The law does lag. You should be frustrated by that. But I know of no perfect way to take care of that other than having really good people like Kirk thinking really hard based on experience about what the analytical platform is, what the framework, what the structure of the house should look like, recognizing, like with some cathedrals, it won't be completed for decades, maybe centuries, but it still gives you that hardcore guidance, rule set to apply even when technology changes, which it does sort of almost every day. So that to me was revelatory in some of the work we did here, and also learning about the work in Ohio and other states to try to be innovative to really help the public in avoiding the mischief that we read about every day.
No, thanks. And I think we're running close to time here, but Kirk, could you give us a quick summary of some of the discussions? So at CIS, we have great credit to Ohio for really showing the way. And we've been involved in discussions with several other states around both cybersecurity laws, but also data privacy. Anything you can share about those discussions?
With other states?
I'm sorry.
You're talking about with other states, or?
Yes, please. I'm sorry, I'm losing my voice again. Yes,
Yeah.
with other states.
Yeah. So this has it's interesting. It hasn't caught. It's caught on. There's five. I think there's five states that have some element of it. Connecticut is the most. It's the closest to what ODPA is, with the exception of it's narrower because it's not a safe harbor for bringing a lawsuit. It gives it basically what it does is it says you can't bring punitives if you have a lawsuit. So the trial bar is a lot more ensconced in Connecticut than they are in Ohio. And so, I mean, it makes sense politically. Again, the states are a laboratory. I've always believed that. I'm a strong believer in federalism and state solutions to problems. So we've got Utah, we've got several others. We thought we had Florida last year, and I still don't understand why Governor DeSantis vetoed it. It passed both houses. I can't recall, but that was going to be Florida's a big state, and that would have been something. Same thing sort of happened in Georgia about 4 or 5 years ago, and it got through one house and didn't get through the other. But yeah, it's a tool. It's a tool, and I'm part. I'll be frank. I think part of the reason why it's not, more people aren't looking to it is that I think regulators have calmed down from what I call the breach wars of 2005 to 2000 and about 12, 13, 14, something like that. But certainly 2005, 2010, when they were hyper aggressive. And I think now, there's a realization that everybody lives in glass houses, and that government has been, taken advantage of probably more so in the last 5 years than any sector. The public sector is under attack daily, at the school level and the local government level, state level, our infrastructure. So I think there's a realization that in a way, this is, and I liked your reference earlier, Tony, about health and wellness. I think this is are things you can do that will make it less likely that you're going to get sick, but you are still occasionally going to get sick, and obviously we all die. But we will. Everybody, nobody's immune to this, and everybody, regardless of how much money you spend, the federal government probably spends more money than anybody on the planet, and our agencies are attacked successfully every year. Some section of them. Yeah. So it's how do you slow them down? And to me, the biggest thing really, and maybe that's the next white paper. It's identification and recovery, right? It's how do you make yourself flexible, and how do you recover quickly and get yourself back online? Just again, eat your Zycam and chicken soup and a lot of rest, and you'll get back on your feet. I mean, there's, you got to have some preparation, and you should go to the gym occasionally, and eat well to prepare for it. So, I mean, I'll just leave it there. But
well, since you mentioned another paper, maybe the memories of all the work last summer have faded. So I appreciate your willingness to even consider that. Sam, if you could kind of bring us home. One thing you riffed on one time when we talked was around the notion of a uniform commercial code.
Yeah.
As this happens, does that make sense in this context?
I'm not sure. I'm a uniform law commissioner, and we work on talk about federalism, work on products to provide to state legislatures to consider to enact. One of the reasons when people wrote checks that you could write a check in state one and cash it in state two was the Uniform Commercial Code, kind of a contractual or a code that dealt with contracts and related issues. I continue to wonder if there's an opportunity here in the state side. There are a couple hands full of states that have looked at this in varying ways. at times using almost identical text and at times using quite different text, which is their prerogative. But I wonder if I was a multi-state or multinational company, perhaps Kirk, like where you worked, if your client might think it would be beneficial to have sort of one unified or nearly so body of state law around the country, recognizing federal government could do it probably, but whether they're going to or not, it's a wildly different question. But to see if there is, a push and can be an enactment to promulgate for the states to look at. We've done that in a variety of different ways, ranging from, like I said, the Uniform Commercial Code, the Uniform Anatomic Gift Act, right? So maybe reasonable cybersecurity and its correlates would be an opportunity there, but we've not yet dug deeply into that vein yet. How about that?
All right, well, I think we're ending. By the way, thanks. I think it's, how this scales is a question for the future. So maybe the next paper, Kirk. I can't wait to draft you for the next meeting here. So, and thanks to you both and to Brian Ray and others who've helped us. You guys have just been extraordinary fun to work with and a lot of great ideas and insight. And thanks for helping us put a statement out from CIS. And again, there'll be more ahead of us. So with that, we're going to wrap up time-wise. If you have other questions, though, I'm reachable. These folks are reachable also, and this is an ongoing conversation for us at the Center for Internet Security.